Article 1101. The heir who is sued shall have the option of indemnifying the plaintiff for the loss, or consenting to a new partition. Indemnity may be made by payment in cash or by the delivery of a thing of the same kind and quality as that awarded to the plaintiff. If a new partition is made, it shall affect neither those who have not been prejudiced nor those have not received more than their just share. 1077a. Article 1102. An heir who has alienated the whole or a considerable part of the real property adjudicated to him cannot maintain an action for rescission on the ground of lesion, but he shall have a right to be indemnified in cash. 1078a. Article 1103. The omission of one or more objects or securities of the inheritance shall not cause the rescission of the partition on the ground of lesion, but the partition shall be completed by the distribution of the objects or securities which have been omitted. 1079a. Article 1104. A partition made with preterition of any of the compulsory heirs shall not be rescinded, unless it be proved that there was bad faith or fraud on the part of the other persons interested, but the latter shall be proportionately obliged to pay to the person omitted the share which belongs to him. 1080. Article 1105. A partition which includes a person believed to be an heir, but who is not, shall be void only with respect to such person. 1081a. Title V. Prescription. Chapter 1. General Provisions. Article 1106. By prescription, one acquires ownership and other real rights through the lapse of time in the manner and under the conditions laid down by law. In the same way, rights and conditions are lost by prescription. 1930a. Article 1107. Persons who are capable of acquiring property or rights by the other legal modes may acquire the same by means of prescription. Minors and other incapacitated persons may acquire property or rights by prescription, either personally or through their parents, guardians or legal representatives. 1931a. Article 1108. Prescription, both acquisitive and extinctive, runs against 1. Minors and other incapacitated persons who have parents, guardians or other legal representatives. 2. Absentees who have administrators, either appointed by them before their disappearance, or appointed by the courts. 3. Persons living abroad, who have managers or administrators. 4. Juridical persons, except the state and its subdivisions. Persons who are disqualified from administering their property have a right to claim damages from their legal representatives whose negligence has been the cause of prescription. 1932a. Article 1109. Prescription does not run between husband and wife, even though there be a separation of property agreed upon in the marriage settlements or by judicial decree. Neither does prescription run between parents and children during the minority or insanity of the latter, and between guardian and ward during the continuance of the guardianship. N. Article 1110. Prescription, acquisitive and extinctive, runs in favor of or against a married woman. N. Article 1111. Prescription obtained by a co-proprietor or a co-owner shall benefit the others. 1933. Article 1112. Persons with capacity to alienate property may renounce prescription already obtained, but not the right to prescribe in the future. Prescription is deemed to have been tacitly renounced when the renunciation results from acts which imply the abandonment of the right acquired. 1935. Article 1113. All things which are within the commerce of men are susceptible of prescription, unless otherwise provided. Property of the state, or any of its subdivisions not patrimonial in character, shall not be the object of Prescription 1936A. Article 1114. Creditors and all other persons interested in making the prescription effective may avail themselves thereof, notwithstanding the express or tacit renunciation by the debtor or proprietor. 1937. Article 1115. The provisions of the present title are understood to be without prejudice to what in this code or in special laws is established with respect to specific cases of prescription. 1938. Article 1116. Prescription already running before the effectivity of this code shall be governed by laws previously in force, but if, since the time this code took effect, the entire period herein required for prescription should elapse, the present code shall be applicable, even though by the former laws a longer period might be required. 1939. Chapter 2. Prescription of ownership and other real rights. Article 1117. Acquisitive prescription of dominion and other real rights may be ordinary or extraordinary. Ordinary acquisitive prescription requires possession of things in good faith and with just title for the time fixed by law. 1940A. Article 1118. Possession has to be in the concept of an owner, public, peaceful and uninterrupted. 1941. Article 1119. Acts of possessory character executed in virtue of license or by mere tolerance of the owner shall not be available for the purposes of possession. 1942. Article 1120. Possession is interrupted for the purposes of prescription, naturally or civilly. 1943. Article 1121. Possession is naturally interrupted when through any cause it should cease for more than 1 year. The old possession is not revived if a new possession should be exercised by the same adverse claimant. 1944A. Article 1122. If the natural interruption is for only 1 year or less, the time elapsed shall be counted in favor of the prescription. N. Article 1123. Civil interruption is produced by judicial summons to the possessor. 1945A. Article 1124. Judicial summons shall be deemed not to have been issued, and shall not give rise to interruption. 1. If it should be void for lack of legal solemnities. 2. If the plaintiff should desist from the complaint or should allow the proceedings to lapse. 3. If the possessor should be absolved from the complaint. In all these cases, the period of the interruption shall be counted for the prescription. 1946A. Article 1125. Any express or tacit recognition which the possessor may make of the owner's right also interrupts possession. 1948. Article 1126. Against a title recorded in the Registry of Property, ordinary prescription of ownership or real rights shall not take place to the prejudice of a third person, except in virtue of another title also recorded, and the time shall begin to run from the recording of the latter. As to lands registered under the Land Registration Act, the provisions of that special law shall govern. 1949A. Article 1127. The good faith of the possessor consists in the reasonable belief that the person from whom he received the thing was the owner thereof, and could transmit his ownership. 1950A. Article 1128. The conditions of good faith required for possession in Articles 526, 527, 528, and 529 of this code are likewise necessary for the determination of good faith in the prescription of ownership and other real rights. 1951. Article 1129. For the purposes of prescription, there is just title when the adverse claimant came into possession of the property through one of the modes recognized by law for the acquisition of ownership or other real rights, but the grantor was not the owner, or could not transmit any right. N. Article 1130. The title for prescription must be true and valid. 1953. Article 1131. For the purposes of prescription, just title must be proved. It is never presumed. 1954a. Article 1132. The ownership of movables prescribes through uninterrupted possession for 4 years in good faith. The ownership of personal property also prescribes through uninterrupted possession for 8 years, without need of any other condition. With regard to the right of the owner to recover personal property lost or of which he has been illegally deprived, as well as with respect to movables acquired in a public sale, fair, or market, or from a merchant's store, the provisions of Articles 559 and 1505 of this Code shall be observed. 1955a. Article 1133. Movables possessed through a crime can never be acquired through prescription by the offender. 1956a. Article 1134. Ownership and other real rights over a movable property are acquired by ordinary prescription through possession of 10 years. 1957a. Article 1135. In case the adverse claimant possesses by mistake an area greater or less than that expressed in his title, prescription shall be based on the possession. N. Article 1136. Possession in wartime, when the civil courts are not open, shall not be counted in favor of the adverse claimant. N. Article 1137. Ownership and other real rights over a movables also prescribe through uninterrupted adverse possession thereof for 30 years, without need of title or of good faith. 1959a. Article 1138. In the computation of time necessary for prescription, the following rules shall be observed. 1. The present possessor may complete the period necessary for prescription by tacking his possession to that of his grantor or predecessor in interest. 2. It is presumed that the present possessor, who was also the possessor at a previous time, has continued to be in possession during the intervening time, unless there is proof to the contrary. 3. The first day shall be excluded and the last day included. 1960a. Chapter 3. Prescription of actions. Article 1139. Actions prescribed by the mere lapse of time fixed by law. 1961. Article 1140. Actions to recover movables shall prescribe 8 years from the time the possession thereof is lost, unless the possessor has acquired the ownership by prescription for a less period. According to Articles 1132, and without prejudice to the provisions of Articles 559, 1505, and 1133. 1962a. Article 1141. Real actions over a movables prescribe after 30 years. This provision is without prejudice to what is established for the acquisition of ownership and other real rights by prescription. 1963. Article 1142. A mortgage action prescribes after 10 years. 1964a. Article 1143. The following rights, among others specified elsewhere in this code, are not extinguished by prescription. 1. To demand a right-of-way, regulated in Article 649. 2. To bring an action to abate a public or private nuisance. N. Article 1144. The following actions must be brought within 10 years from the time the right of action accrues. 1. Upon a written contract. 2. Upon an obligation created by law. 3. Upon a judgment. N. Article 1145. The following actions must be commenced within 6 years. 1. Upon an oral contract. 2. Upon a quasi-contract. N. Article 1146. The following actions must be instituted within 4 years. 1. Upon an injury to the rights of the plaintiff. 2. Upon a quasi-delict. However, when the action arises from or out of any act, activity, or conduct of any public officer involving the exercise of powers or authority arising from martial law including the arrest, detention and/or trial of the plaintiff, the same must be brought within 1 year, as amended by P.D. No. 1755, December 24, 1980. Article 1147. The following actions must be filed within 1 year. 1. For forcible entry and detainer. 2. For defamation, n. Article 1148. The limitations of action mentioned in Articles 1140 to 1142 and 1144 to 1147 are without prejudice to those specified in other parts of this code, in the Code of Commerce, and in special laws, n. Article 1149. All other actions whose periods are not fixed in this code or in other laws must be brought within 5 years from the time the right of action accrues, n. Article 1150. The time for prescription for all kinds of actions, when there is no special provision which ordains otherwise, shall be counted from the day they may be brought. 1969. Article 1151. The time for the prescription of actions which have for their object the enforcement of obligations to pay principal with interest or annuity runs from the last payment of the annuity or of the interest. 1970a. Article 1152. The period for prescription of actions to demand the fulfillment of obligation declared by a judgment commences from the time the judgment became final. 1971. Article 1153. The period for prescription of actions to demand accounting runs from the day the persons who should render the same ceased in their functions. The period for the action arising from the result of the accounting runs from the date when said result was recognized by agreement of the interested parties. 1972. Article 1154. The period during which the obligee was prevented by a fortuitous event from enforcing his right is not reckoned against him, n. Article 1155. The prescription of actions is interrupted when they are filed before the court, when there is a written extrajudicial demand by the creditors, and when there is any written acknowledgment of the debt by the debtor. 1973a. Book IV. Obligations and Contracts. Title I. Obligations. Chapter 1. General Provisions. Article 1156. An obligation is a juridical necessity to give, to do or not to do. N. Article 1157. Obligations arise from 1. Law. 2. Contracts. 3. Quasi-contracts. 4. Acts or omissions punished by law, and 5. Quasi-delicts. 1089a. Article 1158. Obligations derived from law are not presumed. Only those expressly determined in this code or in special laws are demandable, and shall be regulated by the precepts of the law which establishes them. And as to what has not been foreseen by the provisions of this book, 1090. Article 1159. Obligations arising from contracts have the force of law between the contracting parties and should be complied with in good faith. 1091a. Article 1160. Obligations derived from quasi-contracts shall be subject to the provisions of Chapter 1, Title 17, of this book, n. Article 1161. Civil obligations arising from criminal offenses shall be governed by the penal laws, subject to the provisions of Article 2177, and of the pertinent provisions of Chapter 2, Preliminary Title, on Human Relations, and of Title 18 of this book, regulating damages. 1092a. Article 1162. Obligations derived from quasi-delicts shall be governed by the provisions of Chapter 2, Title 17 of this book, and by Special Laws 1093A. Chapter 2, Nature and Effect of Obligations. Article 1163. Every person obliged to give something is also obliged to take care of it with the proper diligence of a good father of a family, unless the law or the stipulation of the parties requires another standard of care. 1094A. Article 1164. The creditor has a right to the fruits of the thing from the time the obligation to deliver it arises. However, he shall acquire no real right over it until the same has been delivered to him. 1095. Article 1165. When what is to be delivered is a determinate thing, the creditor, in addition to the right granted him by Article 1170, may compel the debtor to make the delivery. If the thing is indeterminate or generic, he may ask that the obligation be complied with at the expense of the debtor. If the obliger delays, or has promised to deliver the same thing to two or more persons who do not have the same interest, he shall be responsible for any fortuitous event until he has effected the delivery. 1096. Article 1166. The obligation to give a determinate thing includes that of delivering all its accessions and accessories, even though they may not have been mentioned. 1097A. Article 1167. If a person obliged to do something fails to do it, the same shall be executed at his cost. This same rule shall be observed if he does it in contravention of the tenor of the obligation. Furthermore, it may be decreed that what has been poorly done be undone. 1098. Article 1168. When the obligation consists in not doing, and the obliger does what has been forbidden him, it shall also be undone at his expense. 1099A. Article 1169. Those obliged to deliver or to do something incur in delay from the time the obligee judicially or extrajudicially demands from them the fulfillment of their obligation. However, the demand by the creditor shall not be necessary in order that delay may exist. 1. When the obligation or the law expressly so declare, or 2. When from the nature and the circumstances of the obligation it appears that the designation of the time when the thing is to be delivered or the service is to be rendered was a controlling motive for the establishment of the contract, or 3. When demand would be useless, as when the obliger has rendered it beyond his power to perform. In reciprocal obligations, neither party incurs in delay if the other does not comply or is not ready to comply in a proper manner with what is incumbent upon him. From the moment one of the parties fulfills his obligation, delay by the other begins. 1100A. Article 1170. Those who in the performance of their obligations are guilty of fraud, negligence, or delay, and those who in any manner contravene the tenor thereof, are liable for damages. 1101. Article 1171. Responsibility arising from fraud is demandable in all obligations. Any waiver of an action for future fraud is void. 1102A. Article 1172. Responsibility arising from negligence in the performance of every kind of obligation is also demandable, but such liability may be regulated by the courts, according to the circumstances. 1103. Article 1173. The fault or negligence of the obliger consists in the omission of that diligence which is required by the nature of the obligation and corresponds with the circumstances of the persons, of the time and of the place. When negligence shows bad faith, the provisions of Articles 1171 and 2201, paragraph 2, shall apply. If the law or contract does not state the diligence which is to be observed in the performance, that which is expected of a good father of a family shall be required. 1104A. Article 1174, except in cases expressly specified by the law, or when it is otherwise declared by stipulation, or when the nature of the obligation requires the assumption of risk, no person shall be responsible for those events which could not be foreseen, or which, though foreseen, were inevitable. 1105a. Article 1175. Usurious transactions shall be governed by special laws. N. Article 1176. The receipt of the principal by the creditor without reservation with respect to the interest shall give rise to the presumption that said interest has been paid. The receipt of a later installment of a debt without reservation as to prior installments shall likewise raise the presumption that such installments have been paid. 1110a. Article 1177. The creditors, after having pursued the property in possession of the debtor to satisfy their claims, may exercise all the rights and bring all the actions of the latter for the same purpose, save those which are inherent in his person. They may also impugn the acts which the debtor may have done to defraud them. 1111. Article 1178. Subject to the laws, all rights acquired in virtue of an obligation are transmissible, if there has been no stipulation to the contrary. 1112. Chapter 3. Different kinds of obligations. Section 1. Pure and conditional obligations. Article 1179. Every obligation whose performance does not depend upon a future or uncertain event, or upon a past event unknown to the parties, is demandable at once. Every obligation which contains a resolutory condition shall also be demandable, without prejudice to the effects of the happening of the event. 1113. Article 1180. When the debtor binds himself to pay when his means permit him to do so, the obligation shall be deemed to be one with a period, subject to the provisions of Article 1197. N. Article 1181. In conditional obligations, the acquisition of rights, as well as the extinguishment or loss of those already acquired, shall depend upon the happening of the event, which constitutes the condition. 1114. Article 1182. When the fulfillment of the condition depends upon the sole will of the debtor, the conditional obligation shall be void. If it depends upon chance or upon the will of a third person, the obligation shall take effect in conformity with the provisions of this Code. 1115. Article 1183. Impossible conditions. Those contrary to good customs or public policy and those prohibited by law shall annul the obligation which depends upon them. If the obligation is divisible, that part thereof which is not affected by the impossible or unlawful condition shall be valid. The condition not to do an impossible thing shall be considered as not having been agreed upon. 1116a. Article 1184. The condition that some event happen at a determinate time shall extinguish the obligation as soon as the time expires, or if it has become indubitable that the event will not take place. 1117. Article 1185. The condition that some event will not happen at a determinate time shall render the obligation effective from the moment the time indicated has elapsed, or if it has become evident that the event cannot occur. If no time has been fixed, the condition shall be deemed fulfilled at such time as may have probably been contemplated, bearing in mind the nature of the obligation. 1118. Article 1186. The condition shall be deemed fulfilled when the obliger voluntarily prevents its fulfillment. 1119. Article 1187. The effects of a conditional obligation to give, once the condition has been fulfilled, shall retroact to the day of the constitution of the obligation. Nevertheless, When the obligation imposes reciprocal prestations upon the parties, the fruits and interests during the pendency of the condition shall be deemed to have been mutually compensated. If the obligation is unilateral, the debtor shall appropriate the fruits and interests received, unless from the nature and circumstances of the obligation it should be inferred that the intention of the person constituting the same was different. In obligations to do and not to do, the courts shall determine, in each case, the retroactive effect of the condition that has been complied with. 1120. Article 1188. The creditor may, before the fulfillment of the condition, bring the appropriate actions for the preservation of his right. The debtor may recover what during the same time he has paid by mistake in case of a suspensive condition. 1121a. Article 1189. When the conditions have been imposed with the intention of suspending the efficacy of an obligation to give, the following rules shall be observed in case of the improvement, loss or deterioration of the thing during the pendency of the condition. 1. If the thing is lost without the fault of the debtor, the obligation shall be extinguished. 2. If the thing is lost through the fault of the debtor, he shall be obliged to pay damages. It is understood that the thing is lost when it perishes, or goes out of commerce, or disappears in such a way that its existence is unknown or it cannot be recovered. 3. When the thing deteriorates without the fault of the debtor, the impairment is to be borne by the creditor. 4. If it deteriorates through the fault of the debtor, the creditor may choose between the rescission of the obligation and its fulfillment, with indemnity for damages in either case. 5. If the thing is improved by its nature, or by time, the improvement shall inure to the benefit of the creditor. 6. If it is improved at the expense of the debtor, he shall have no other right than that granted to the usufructuary. 1122. Article 1190. When the conditions have for their purpose the extinguishment of an obligation to give, the parties, upon the fulfillment of said conditions, shall return to each other what they have received. In case of loss, deterioration or improvement of the thing, the provisions which, with respect to the debtor, are laid down in the preceding article shall be applied to the party who is bound to return. As for the obligations to do and not to do, the provisions of the second paragraph of Article 1187 shall be observed as regards the effect of the extinguishment of the obligation. 1123. Article 1191. The power to rescind obligations is implied in reciprocal ones. In case one of the obligers should not comply with what is incumbent upon him, the injured party may choose between the fulfillment and the rescission of the obligation, with the payment of damages in either case. He may also seek rescission, even after he has chosen fulfillment. If the latter should become impossible, the court shall decree the rescission claimed, unless there be just cause authorizing the fixing of a period. This is understood to be without prejudice to the rights of third persons who have acquired the thing, in accordance with Articles 1385 and 1388 and the Mortgage Law. 1124. Article 1192. In case both parties have committed a breach of the obligation, the liability of the first infractor shall be equitably tempered by the courts. If it cannot be determined which of the parties first violated the contract, the same shall be deemed extinguished, and each shall bear his own damages. N. Section 2. Obligations with a period. Article 1193. Obligations for whose fulfillment a day certain has been fixed shall be demandable only when that day comes. Obligations with a resolutory period take effect at once, but terminate upon arrival of the day certain. A day certain is understood to be that which must necessarily come, although it may not be known when. If the uncertainty consists in whether the day will come or not, the obligation is conditional, and it shall be regulated by the rules of the preceding section. 1125a. Article 1194. In case of loss, deterioration or improvement of the thing before the arrival of the day certain, the rules in Article 1189 shall be observed. N. Article 1195. Anything paid or delivered before the arrival of the period, the obliger being unaware of the period or believing that the obligation has become due and demandable, may be recovered, with the fruits and interests. 1126a. Article 1196. Whenever in an obligation a period is designated, it is presumed to have been established for the benefit of both the creditor and the debtor, unless from the tenor of the same or other circumstances it should appear that the period has been established in favor of one or of the other. 1127. Article 1197. If the obligation does not fix a period, but from its nature and the circumstances it can be inferred that a period was intended, the courts may fix the duration thereof. The courts shall also fix the duration of the period when it depends upon the will of the debtor. In every case, the courts shall determine such period as may under the circumstances have been probably contemplated by the parties. Once fixed by the courts, the period cannot be changed by them. 1128a. Article 1198. The debtor shall lose every right to make use of the period. 1. When after the obligation has been contracted, he becomes insolvent, unless he gives a guarantee or security for the debt. 2. When he does not furnish to the creditor the guarantees or securities which he has promised. 3. When by his own acts he has impaired said guarantees or securities after their establishment, and when through a fortuitous event they disappear, unless he immediately gives new ones equally satisfactory. 4. When the debtor violates any undertaking, in consideration of which the creditor agreed to the period. 5. When the debtor attempts to abscond. 1129a. Section 3. Alternative obligations. Article 1199. A person alternatively bound by different prestations shall completely perform one of them. The creditor cannot be compelled to receive part of one and part of the other undertaking. 1131. Article 1200. The right of choice belongs to the debtor, unless it has been expressly granted to the creditor. The debtor shall have no right to choose those prestations which are impossible, unlawful, or which could not have been the object of the obligation.